Good morning, good afternoon. My name is Bob Iber. I'm the Acting Deputy Assistant Secretary for Multifamily Housing Programs. Welcome to Multifamily Housing's second of two training broadcasts on requirements of HUD's final rule implementing the 2013 Violence Against Women Act. The first training broadcast covered VAWA final rule from an owner-agent perspective. Today's webcast will cover the VAWA final rule from the perspective of HUD staff and staff working at the Performance-Based Contract Administrators, or the PCBAs. Sitting next to me are our presenters for the training, Danielle Garcia and Anicia Durr. Carissa Janis is also with us today. She is in the studio fielding live questions that you can submit during the presentation. As you know, the VAWA rule was published on November 2016, and we published Housing Notice 2017-05 on June 30th. Both our final rule and the notice are critical steps in protecting affordable housing opportunities for people experiencing domestic violence, dating violence, and sexual assault and stalking. The final rules changes to VAWA are significant for multifamily housing. The requirements now apply to all assisted housing properties, including Section 202 and 811 PRACs. HUD guidance on the implementation of VAWA final rule is long awaited, and I could not be more pleased that Housing Notice 2017-05 is now available to you. Since November 2016 publication of the VAWA final rule, I know PBCAs and field staff have received numerous questions regarding the rule's effect on VAWA covered housing properties. I want to personally thank each of you for your tireless efforts in providing the industry with the answers and positive reinforcement. Thank you for joining us, and we hope you find this training helpful as you support the implementation of the VAWA final rule. Now I will turn it over to Danielle, who will cover the agenda for today, and I can assure you Danielle is a better reader than I am. So I'll turn it over to Danielle.
Great, thanks Bob. And so as Bob mentioned, I will cover the agenda. I am pleased with the opportunity to speak with you today on a topic of which we are here at HUD headquarters have gotten numerous questions. Our team has worked hard on putting guidance together, and I share with Bob's delight in making this long-awaited publication available to you. So today we'll cover, Anicia is going to cover the first half of training. Her topics will include the overview of the VAWA final rule, notice of occupancy rights, which is Form HUD 5380, and the certification Form 5382, the VAWA lease addendum, that's HUD Form 91067, and documentation of occurrences for a request for VAWA protections. I will cover the latter part of the presentation. My topics will include lease bifurcation, emergency transfer plan, keeping your records confidential, and how to maintain your records as far as record keeping, and looking at the management and occupancy review of filling out the HUD Form 9834. So if you tuned into last week's webcast, we got more into the nuts and bolts of some of the VAWA final rule changes and requirements. The webcast for the VAWA final rule from owner-agent perspective has been archived through HUD website and is available for your viewing. We also sent out a RIP listserv to y'all. We will provide a brief overview or introduction on each topic and a few things to look for when enforcing compliance. For those of you who may perform MORs, we will also discuss a few recommendations for corrective actions for identified infractions. Keep in mind that these are only suggestions. It should not be considered mandatory, but to also reach out to us if you have questions. I also want to mention, as Bob said, that we will be taking in questions live, so please contact Carissa, L, Janis at HUD.gov. Again, that's Carissa, L, Janis at HUD.gov. And send us your questions, and we will get through as many as we can throughout the presentation. And we look forward to your feedback. Now I'm going to turn things over to Anicia.
Thank you, Danielle. And thank each of you for tuning in with us today. And if you tuned in last week, I'm appreciative that you are back with us today. It is my hope that you walk away from today's presentation with a point of reference that you can use at a later time or receive some answered question. Housing Notice 2017-05 provides guidance to owners and management agents of HUD multifamily assisted housing on the requirements of the Violence Against Women's Reauthorization Act of 2013. Implementation in HUD Housing Program Final Rule published in the Final Register on November 16, 2016. Keep in mind that the notices do not encompass all aspects of the VAWA Final Rule and should be used in conjunction with the Final Rule. The Final Rule implemented several key changes related to housing protection for victims of violence, domestic violence, dating violence, sexual assault, or stalking. Today, I will not go into detail regarding changes to the VAWA rule that the VAWA rule brought about. But I will mention that one of its core aspects is to provide clarification that HUD housing programs may not deny or terminate applicant or tenant assistance or tenancy on the basis or as a direct result of the applicant or tenant currently or having been a victim of a VAWA crime, if the applicant or tenant otherwise qualifies for admission, assistance, or occupancy. A summary of major changes can be reviewed in Section 4 of the housing notice. I also want to point out that Section 5 of the housing notice provides definitions of terms that were frequently referred to in the final rule. Be sure to familiarize yourself with those terms. There are some new and or updated forms for you to look out for. The Notice of Occupancy Rights, which is Form 5380, the Model Emergency Transfer Plan, which is Form 5381, the Certification of a VAWA Crime, which is Form 5382, the Emergency Transfer Request, which is Form 5383, the VAWA Lease Addendum, which is Form 91067. Will also be updated to include provisions of the final rule. The forms that are currently on HUD clips are expired, but we are encouraging continued use of these forms until updated forms are released. The VAWA PRA packet, it was actually published today, and it will be posted for public comment for a period of 60 days, and I believe it'll be available for comment until October the 2nd, I believe it is. So make sure that you take time to, if you have any comments, and just comment on those forms. Just make sure that those forms that are published that were published today, make sure you don't use those forms because they are not approved yet. They only have proposed changes, and so just make sure you don't use those. But and that's something that, as a reviewer, when you go out, you want to make sure that that owners and agents are not using those unapproved forms. Keep in mind that the VAWA final rule is applicable to all assisted multifamily housing programs, to include the family, the elderly, and the disabled properties. So that includes the project-based Section H or PACs, the PRACs, the SPRACs, the 236, the 811 PRA, and 221 D3 and D5. VAWA protections should be made available to applicants and tenants of HUD housing programs who are victims of a VAWA crime. It is not limited to women. It is available to all without regard to sex, gender identity, or sexual orientation. Guests, unassisted household members, and live-in aides are not eligible for protections. However, as a reasonable accommodation, a tenant can request VAWA protections if a live-in aide is a victim. They may request an emergency transfer for the household. So keep in mind that tenants cannot be evicted or have assistance terminated based on a guest unassisted member or a live-in aide being a victim of a VAWA crime. All requirements and provisions of the final rule are now in effect. Although most were in effect December 16, 2017, the emergency transfer plan was required just last month, which is June 14, 2017. The core protections and confidentiality rights of the notice of occupancy rights cannot be changed. Things can be added such as the property name, the organization name, the covered housing program type. For example, the section, they can add Section 8 or the PRA, 811 PRA. Terminology pertinent to the program type that makes the notice more meaningful to applicants and tenants can also be added. The notice for occupancy rights, 5380, must be provided in conjunction with the certification form, which is Form 5382. The 5380 and 5382 must be provided to rejected applicants. They must be provided to new move-ins. They must be provided with notices of eviction or termination of assistance. They must be provided to each household member during annual recertification no later than December 15, 2017. The certification form 5382. Note that the 5382 replaces the 91067 Form 91066. Form 91066 is now obsolete and should not be used. As I stated, Form 5382 should be provided along with Form 5380. So just make sure that that owners and agents are no longer using the 91066. Forms 5380 and 5382 must be provided with each notice of eviction and each termination of assistance, no matter what the reason, whether it be material noncompliance, criminal activity, failure to respond to recertification, failure to move to a different size unit, or increased in income. The form should be provided once for each action. For instance, if a owner issues a notification of termination of assistance because the household's income disqualifies them from receiving subsidy, the forms will be needed to be provided. If the owner issues the same household a notice of eviction for a criminal activity, the forms will be needed to provide. The forms will need to be provided again. Excuse me. Owners must abide by termination guidelines set forth in the Chapter 8 of the HUD Handbook 4350.3, as well as any other local and state laws. A few things to look for. In regards to the 5380 and 5382. Make sure there are no changes or exclusions to core protections and confidentiality rights. Although the final rule does not require acknowledgement of receipt of the forms, does not require acknowledgement of receipt. Look for the evidence that the forms were provided with the 2017 annual recertification. If no acknowledgement of receipt is present, discuss this with the owner during the exit interview of your MOR, encouraging them to do so. Communicate to them that acknowledgement, documentation, or evidence may be in different forms. It may be included in a page of acknowledgement. It may be noted in the file or just noted on a copy that was actually provided to the tenant. Just a few suggested corrective actions during the MOR. If things are identified during the MOR, here are a few suggested corrective actions. If corporate components of the confidentiality rights of the notice of occupancy rights have been changed, consider issuing a finding requiring the owner to make the appropriate corrections. Consider an observation for recommendation for not providing the 5380 and 5382 to current residents during the annual and during their annual recertification by December 15, 2017. Considered issuing a finding for not providing the forms at other required events such as eviction, termination of assistance, rejected applicant, or a move-in. Okay, as I mentioned earlier, HUD will soon issue an updated Form 91067 to include new provisions. Form 91067 now apply to all multifamily housing programs. Section 8 properties should continue using the current form and provide a revised form to current households at their next annual certification and to new move-ins. Because the current addendum is applicable to only Section 8 properties, all other programs should not use the current Form 91067 and should wait until the updated form has been issued. A few suggested corrective actions for the Section 8 program: issue a finding if owner is not issuing the updated form. Until the updated form is issued, make sure owners are using the existing form and have not amended it on their own. All other programs are not required to provide the HUD 91067 until the updated version is released. Then once the HUD 91067 is updated, all covered housing projects must use the updated version. Okay. Now it's time for some questions. Danielle, do we have any questions come in?
Yeah, it looks like a few have come in here. Just to provide some clarification, I think, because we are getting lots of questions with our PRA packages, is the 4 forms that are out on the Federal Register that were published today. Those are the 5380, 5381, 5382, and 5383.
Yes.
So those 4 forms in the Federal Register, y'all can take a look, give us comments with what we're proposing changes to existing forms on HUD clips. And the 91067 form is in a different PRA package, so that form is not included. So that's still waiting to get published in the Federal Register for that PRA package. And that form is part of the tracks submission package, so we're working with Lanier Hilton to get that form on the streets.
Good point.
At least for comment.
Good point. Thank you, Danielle.
Yep. So let's see. So one question is, if during an MOR of a property with mixed funding, it is noted that owner agents implemented requirements of the final rule on its non-subsidy programs. So is this acceptable? Can somebody who, it sounds like the question is, if you have a multiple layered program and the HUD final rule was implemented to their non-HUD assisted units, can that happen?
Okay. Although the final rule apply only to applicants and tenants of HUD-covered housing programs, owners may choose to extend VAWA protections and remedies to tenants and the applicants of other housing programs. If that's where they're applicable. It is strongly suggested that properties with tax credit units seek guidance from the Department of Treasury, which is the IRS, or the appropriate HFA for guidance on implementing the final rule for those units. You may refer to also, you may also refer to Section 2 of the Housing Notice for all the applicable programs.
Okay.
Okay.
Okay, so next question is a long one. So the last page of Notice of Occupancy Rights Form 5380 indicates that tenant applicant may report a covered housing provider's violation of VAWA rights by contacting or filing a complaint with an intermediary if the property has one, or the local HUD field office. If the property has an intermediary, is it required that the property list the field office as well, or can they list one or the other?
With that particular one, I believe that's on page 8 of the Notice of Occupancy Rights. They give the victim the choice if they feel like they've been discriminated against. They give them a place to report that if they feel like they've been discriminated against. And I believe the owner or agent, it's a space for them to plug in the intermediary if they have one, or either the HUD field office.
Okay.
If they have an intermediary, such as a PCBA, of course they should add that information in there. But it is strictly up to the owner or the agent if they want to add both.
Okay.
It's strictly up to them.
Okay, great. So one more question here. Is it acceptable for an owner agent to give the 5380 and 5382? So that's the Notice of Occupancy Rights and Certification form.
Mm-hmm.
So those two forms to all residents once during their annual research and have them sign an acknowledgement. So I think the question is it required to do, can they give those two forms all at once as soon as they saw this VAWA notice that those two forms are required, or do they have to wait till the AR?
Okay. Yes, yeah. Now, the VAWA final rule, it specifies that the 5380 and 5382, they must be given to each household at each household's annual recertification during the first year of the VAWA final rule is in effect. An owner may choose to provide the forms at a different time to all current residents, but in order to meet the requirements of the VAWA final rule, they will still need to provide the forms again at the annual recertification. This is a regulatory requirement, and there's no flexibility in that. Owners are encouraged to provide the forms at any additional times determined to be helpful in informing the tenants of their rights under VAWA. HUD also encourages owners to post the Notice of Occupancy Rights on their website and in public areas such as the waiting room at community bulletin boards, the lobby, or where all tenants may view them. This will be particularly helpful for households whose next annual recertification, it may be months away. However, even if the forms are provided in other ways, owners still must provide them at the household annual recertification.
Yep, good point. And I'd just like to add, in one of the slides previously, what we're recommending if you're HUD staff or PBCA doing the MOR, to give a recommendation if that form was not given at the annual research. It's not required that the owners sign the acknowledgement. If they do, that's great, just to document that it was done and the action was complete. But just make sure that through conversations, your exit interview, that notice does get done for all annual research. If owners missed annual research, then just get it out as soon as possible. That way the tenants are aware of their VAWA rights.
Yes. Thank you, Danielle. Okay, the certification of victim status. There has been some changes to the certification of victim status process. Owners may accept verbal request or certification, or they may require written request certification or other forms of documentation. If it is the owner's policy that the request for VAWA protections be in writing, they must communicate this to the victim in the forms of a written dated letter. Either way, the owner cannot require more than one type of documentation. An applicant or tenant may satisfy the owner's request by providing any one of the following, which is the certification form, which is 5382, or a document signed or a document which has been signed from a professional from whom the victim sought assistance, that specifies under the penalty of perjury that the professional believes in the occurrence of the incident of a VAWA crime that is the ground for protection and remedies under the VAWA final rule, or a record from a governmental law enforcement or administrative agency or court. If the applicant or tenant satisfy the owner's request for documentation and the submitted documentation does not contain conflicting information, the owner may accept, yes, the owner may also, the owner also has discretion to accept a statement or other evidence. More on this can be found in the Code of Federal Regulation, which is 5.207B1, and then also in the housing notice, which is Section 7. Owners are encouraged to develop written policies as to whether verbal or written requests will be required. Other than policies regarding the admission and or placement of victims, HUD does not have a position on where VAWA policies are located or placed. We have seen some owners adopt standalone policies while others have included policy in the tenant selection plan or in the house rules. Owners are prohibited from denying an applicant admission, terminating assistance, and or evicting a tenant based on an adverse factor. If the adverse factor is determined to be a direct result of the fact that the applicant or the tenant is or has been a victim of a VAWA crime. An applicant or tenant must first inform the owner that he or she is a victim and provide enough information for the owner to make that determination regarding the adverse factor. An owner may consider documentation of adverse factors resulting from being a victim that otherwise deem the individual ineligible. Some examples of adverse actions are poor credit history, which resulted from may have been a result from the abuser use of the victim's credit, poor rental history, which resulting from early lease termination, and then also a criminal record resulting from a victim being forced maybe to write bad checks or misuse credit or file fraudulent tax returns. Failure to pay rent resulting from an abuser preventing the victim from obtaining and or maintaining employment. An objective, reasonable determination of whether the adverse factor is a direct result of the applicant or tenant being or having been a victim must be made. In doing so, for clarification purposes, additional information may be needed. Response time. Now, owners, they may set time restraints. They may require the victim to provide documentation within 15 business days after the date of the individual received the written, 14 days after the date the individual received the written request for the documentation. However, the owner may extend this period at its discretion. Now, keep in mind that during this 14-day period, and any granted extensions, no adverse actions such as evictions or terminations can be taken against the individual requesting VAWA protections. For example, an eviction cannot be implemented during this time frame if the applicant or tenant fails to provide documentation within the allotted time. Nothing in the VAWA final rule may be construed to limit the authority of the owner to deny admission, terminate assistance, or evict the individual. Another thing to remember is that an applicant or tenant's failure to timely provide documentation does not result in a waiver of the individual's right to challenge the denial of assistance or termination. If the owner denies VAWA protections, they must follow established appeal procedures as set forth in the HUD Handbook 4350.3, and I believe that is in Chapter 8, Section 3 of Chapter 8. The conflicting claim of evidence. More than one party may claim victim status, or initial documentation given to an owner may contain contradictory information already available to the owner. If an owner has a policy of requesting third-party documentation when there are conflicting certifications, additional documentation may be requested from both parties. If submitted documentation meets the criteria in the final rule, the owner must accept the submitted documentation and is prohibited from seeking additional documentation of VAWA status. Owners are prohibited from conducting interviews with neighbors or employers to determine if the applicant or tenant is or is an actual victim of a VAWA crime. Doing so may result in a violation of the tenant's confidentiality requirements of the VAWA final rule. However, if the owner already has or regularly receives reliable information that conflicts with the submitted documentation, the owner may require third-party documentation of victim status based on the information outside of the submitted documentation. And some examples of this information may be surveillance footage, police reports, and other verifiable information. This information must not be collected for purposes of discrediting the claim for VAWA protections, but it may be collected for those legitimate reasons, such as addressing safety in the community. The property's written policy should align with their current practices. The property's discretion to accept verbal or written requests or certification or documentation should be clear and consistent. If their policy to require written requests or certification within the VAWA file, there should be evidence that this was communicated to the victim in the form of a dated letter. A VAWA file should not contain documentation of request. A VAWA file should contain documentation of requests and the owner's response and the property's final determination. If adverse factors were considered, there should be documentation to support the property's final decision. A few other things to look for. If there's a case of conflicting claims or evidence, documentation should show how the issue was resolved. There should be documentation that the applicant or tenant claim is or is not valid and initial action was appropriate. If the owner's initial determination was appealed, it should be processed in compliance with the established grievance procedures. The time frame of the owner's response should be in a reasonable time period. Okay. Management and occupancy review. Now, during the MORs, inquire about the number of the tenants or the applicants requesting the VAWA protections. If there has been a claim, request to see the file. For corrective actions, consider using a finding if the required documentation as stated in the tenant selection plan or the policy, which is that may be found in the house rules as well, is not in the file. Use discretion when issuing corrective actions for owners' compliance with placement or content or written policy within the TSP and the house rules. Okay, we have more questions. We have more questions in.
Okay, so yeah, just a reminder, continue sending your questions to us at carissa.l.janice@hud.gov. So first question is, should we review the tenant selection plan to ensure that VAWA language is included?
Yes. It is required that the TSP be updated to reflect the preference and any other policy regarding tenant selection affected by changes implemented. Keep in mind that owners have the discretion of the placement of the adopted policies, whether it be a standalone policy or just kind of interwoven or bleeded through the tenant selection plan and the house rules. And then also also keep in mind that that current Section 8 programs, they should already have something about the VAWA rule in the TSP, but this is new to like 202s and 811, so they will need to be added to the TSP.
No, that's a great point. In the HUD Handbook 4350.3, it's Figure 4-2. It was already an existing requirement that VAWA protections are included in tenant selection plans for Section 8 programs. So I think for your Section 8 owners, you're just going to have to review what you have in your written policy, finesse it a little bit. And then for your 202 and 811 pracs, you're going to be adding this new requirement in the tenant selection plan.
Yes.
Good point.
Yeah.
Okay, so next question. If an individual requesting VAWA protections does not provide requested documentation within the required time, but the owner still administers the protection, should the owner be considered out of compliance?
Well, owners, they may consider extenuating circumstances that may cause a delay in the victim's circumstances, so it might not fall exactly in the time period that they requested. However, this should be documented to show that the delay was reasonable.
Okay. All right, and it looks like one more here. The VAWA final rule in housing notice 17-05 does not indicate that documentation of VAWA claim should be maintained in a file separate from tenant leasing folders. Is this still required?
Yes, yes it is. And the VAWA final rule and the housing notice does not specifically state that the VAWA document be maintained in a specific location. However, the regulations, the Code of Federal Regulations, and I believe it's at 5.2007C, restricts disclosure of VAWA information to individuals other than the victim unless specific conditions are met. Because domestic violence often occurs within the household and the members of the household can review the tenant file, the regulations call for confidential record keeping in a location other than the tenant file. This requirement is also stated in the HUD Handbook 4350.3, which requires owners to retain all documentation related to an individual's VAWA claim in a separate file that is kept in a separate secure location from other tenant files.
Okay. Great. And it looks like I am next on the list, so if you wouldn't mind doing the PowerPoint. So next we're going to go over lease bifurcation. Lease bifurcation is the occurrence of domestic violence, dating violence, sexual assault, or stalking that may lead to a breakup of the assisted family. A family breakup involves terminating assistance of the perpetrator while continuing assistance to the victim. So in Notice 17-05, quote-unquote, bifurcate means to divide a lease so that certain tenants can be evicted or removed, and the remaining tenants or lawful occupants can continue to reside in the unit under those same lease requirements. So essentially that perpetrator is taking off the lease and the new lease executed with the victim and other eligible household members. Now, lease bifurcation does not apply to guests, unreported household members, or anyone who is not a tenant. And next slide. So the VAWA final rule establishes a reasonable time period for remaining family members to demonstrate eligibility for housing assistance or find alternative housing following lease bifurcation. Remember that the remaining family member has to meet statutory requirements for housing assistance, Examples could include checking immigration status, the age of remaining household members, and disability status. In most cases, the owner agent must provide family members a period of 90 calendar days from the date of lease bifurcation. However, there's a few exceptions to this rule. So for your 202-811 PRAC owners, you have 90 calendar days, or when the lease expires, whichever's first, to meet that eligibility criteria for age and disability. For your Section 202-8s, your Section 8s and 236s, you have 30 calendar days to establish immigration status. And the period will not apply beyond the expiration of the lease unless permitted by program regulations. Eviction removal, termination of occupancy rights, or termination of assistance must be in accordance with federal, state, or local law for termination of leases. For example, some jurisdictions may prohibit partial or single tenant evictions. To avoid unnecessary delay in the bifurcation process, HUD recommends that the owner agent seek court-ordered eviction of the perpetrator pursuant to applicable laws. This process results in underlying lease becoming null and void once the owner regains possession of the unit. The owner would then execute a new lease with the victim. HUD also encourages owners to simultaneously attempt to reach agreement to the mutual termination of the lease if it is safe to do so. Remember that removing a household member from the lease is also changing family composition, so you may require the victim to move to another unit if the appropriate size. You should, of course, follow your occupancy standards and your tenant selection plan for determining the appropriate size unit for that family. Now, eviction or termination of assistance should only be used by an owner or agent when there are no other actions or remedies to reduce or eliminate threat, including when actions or remedies are unavailable. Owners and agents may evict a victim or terminate assistance if they can demonstrate that an actual and imminent threat to other tenants or those employed at or providing services to the property would be present if the tenant or lawful occupant is not evicted. And in order to demonstrate an actual and imminent threat to other tenants or employees at the property, the owner agent must have objective evidence or words, gestures, actions, or other indicators of such threat. In determining whether an individual would pose an actual and imminent threat, the factors to consider would include the duration of the risk, the nature and severity of potential harm, the likelihood that the potential harm would occur, and the length of time before the potential harm would occur. So here's a couple things to look for when you're doing your tenant file reviews. Is in cases of family breakup or lease bifurcation. So was the perpetrator provided adequate notification within the proper time frame and in accordance with federal, state, and local laws? If applicable, was the adequate time allotted for the remaining household members to establish eligibility or seek alternative housing after the date of lease bifurcation? The time period to establish eligibility or find alternative housing cannot extend beyond the expiration of the lease. There should be some documentation of the remaining family members meeting statutory requirements for housing assistance. So that's your immigration status, age of remaining family members, and disability status. So slide 31, because evictions of termination should only be performed when no other actions are available, there should be documentation of other options that were offered. For example, barring the perpetrator from the property where local and state laws permit, changing the victim's locks pursuant to owner agent's lock replacement policy and state and local laws, and encouraging victims to seek an emergency transfer, allowing an early lease termination, or helping the victim access available services. A few other things to look for include if an eviction, removal, or termination was performed, was it performed in accordance with applicable laws? And did the owner agent follow established grievance procedures? If there is a change in rent, was proper notification provided for the increased or decreased rent? And a lease bifurcation will also change the family composition, so the remaining family members may not meet the occupancy standards for the current household, and just making sure that y'all are looking at if they are overhoused or underhoused, probably in this instance underhoused, or overhoused rather, anyway, that they are on the unit transfer wait list. So is that documentation available, and looking at their unit transfer wait list policies. Next slide. Okay, so when performing an MOR, that's Management Occupancy Review, the reviewer should consider issuing findings for infractions regarding establishing eligibility and performing timely move-outs and your interim recertifications. The reviewer should issue a finding for infractions regarding performing evictions, so that's you're looking at was the proper notice provided and following applicable laws. Because of the complexity may be involved, the reviewer should use discretion in issuing corrective actions for documentation of owner agents, evaluation of cases of actual and imminent threat. So now it's time for a few questions here.
Okay, let's see. We have one here. If a resident calls us for help, indicating that they don't feel comfortable talking to the property management staff, what should we do?
So I think the us means HUD staff, so the
staff.
residents calling HUD. So in that case, you would ask the resident if it's okay to mention the resident's name to the management company. You should provide information on service providers. I think that would be helpful as well. You can give all of that documentation to the resident and phone numbers, et cetera, addresses. However, since HUD and the PCBA staff aren't familiar with local communities, we understand that there's only so much information that you can provide to the family, but I think it's just, good communication.
Yes.
Yeah.
I agree. Okay, next question. During a bifurcation, the remaining tenant asks management to change the unit's locks so the abuser will not have access to the unit. Can the owner change the household lock prior to completing the eviction process?
Okay, great question. So if the victim requests to change locks, the owner agent should follow y'all's established property policy and procedure. The main thing is looking at your state and local laws regarding unit access. I think those could vary between jurisdictions. So you should also seek legal counsel to ensure your state and local laws are followed regarding the lock policy. And I think this one's a little tricky because if you have a perpetrator who's a part of the lease, that is going to be a little hairy. So
Yes.
reaching out to your counsel with how you should handle that. If it's an instance where the perpetrator is not a member of the lease and maybe a boyfriend of a resident, that would be an easier solution, right?
Yes.
Where you can easily change the locks because that person is not on the lease.
Yes, I agree. Okay, we have another one. If the accused perpetrator is the only qualifying member and moves out of the unit, does the remaining household continue to pay the current rent?
That's a good question. So when the perpetrator moves out, an interim recertification is performed using the remaining household members' income and deductions for determining rent. The VAWA final rule and the notice establishes a reasonable time period for those remaining family members to demonstrate eligibility for housing assistance and find alternative housing. If the remaining family member will not be able to establish that eligibility within the required time frame, then in those cases, the remaining family member must then pay the market rent, contract rent, or operating rent for that unit for the duration of that established time period, which is that 90 calendar days,
Okay.
or when the lease expires.
All right. Thank you. And just remember to continue to send your questions to carissa.l.janice@hud.gov.
Okay, so next we will go over our emergency transfer plan. We're going to, again, tell y'all the difference between external and internal transfers. So there has been some confusion about what's considered an internal transfer. And basically, an internal transfer is a relocation of a tenant from your property from one unit to another. So you're essentially doing a unit transfer in tracks, a UT, and that's considered internal transfer. Your external emergency transfers is the relocation of a tenant from one property to another property. So that one you would do a move out at your property, and then property B then would do a move in. And next slide. Okay. So we are on slide 35. Okay. Let's see. So emergency transfer plans, the VAWA 2013 requires owner agents to assist victims in making internal or external unit transfers when possible. Slide 35, thank you. Transfer to a safe unit, tenant determines what is the safe unit. So when you're having these conversations with the family, it's important for the family to determine what is safe. You as an owner need to determine what is available. So owner agent must create and implement an emergency transfer plan based on HUD's model form. That's the 5381. And this model form is available in HUD clips. The VAWA 2013 requires owner agents to assist victims in making internal or external transfers when possible. Owner agents must adopt this emergency transfer plan no later than June 14th, 2017. So this is news to you. We mentioned this on last week's webcast. Please make sure that you're starting to craft that. Later in the presentation, we will go over compliance and enforcement from HUD PBCA perspective. So that current model 5381 does not contain all required criteria stated in the VAWA final rule. The model only contains general provisions of an emergency transfer plan that apply across covered housing programs. Adoption of this model plan without further information will not be sufficient to meet a covered housing provider's responsibility to adopt the emergency transfer plan. Owner agents must consult applicable regulations and program-specific HUD guidance when developing your emergency transfer plan to ensure their plans contain all required elements. Thank you. Slide 36. The emergency transfer plan must provide that a tenant residing in subsidized unit under PBRAs, that's your project-based rental assistance, and who is a victim of domestic violence, dating violence, sexual assault, or stalking qualifies for an emergency transfer if the tenant expresses that request of the transfer and either one of the two. The tenant reasonably believes that there is a threat of imminent harm from further violence if the tenant remains within the same dwelling unit, or in the cases of sexual assault, the tenant believes that there is a threat of an imminent harm from further violence if the tenant remains in the same unit that the tenant is currently occupying, or the sexual assault occurred on the premises 90 calendar days preceding that date of the requested transfer. So request does not guarantee that continued assistance will be available to that external transfer to other HUD housing, and the tenant must meet outstanding eligibility or occupancy requirements at that new owner that it's transferring to. Slide 37, thank you. Owners and agents may establish an admission preference for victims of domestic violence, dating violence, sexual assault, or stalking. And an owner agent does not need HUD approval to adopt a VAWA preference. This is an acceptable owner preference under 24 CFR 5.655 C4. Owner agents must modify their tenant selection plan to include the owner adopted preference. The tenant selection plan will be reviewed during the property's MOR. And owners and agents may also establish a waitlist priority for internal transfers. Owner agents will need to amend the tenant selection plan for priorities of the internal transfer waiting list. And slide 38, thank you. Just a few things to pay attention to when you're doing your MORs is the emergency transfer plan compliant with VAWA final rule and HUD notice 17-05 requirements? And is the owner agent actions consistent with their adopted emergency transfer plan? If the owner agent adopted a VAWA preference or some type of priority for their internal transfers, does the tenant selection plan reflect those preference priorities changes? And both the internal and external waitlist should reflect preferences or priorities that may have been applied in accordance with the property's tenant selection plan. Some house rules may discuss transfers and VAWA protections. If this is the case, make sure that your house rules are updated accordingly. Next slide, thank you. So on the MOR, management occupancy reviews, Some corrective actions for MORs may include for MORs conducted after the publication of Housing Notice 17-05, which was published on June 30th. For MORs conducted June 30th through December 13th, 2017, reviewers should issue a recommendation rather than a finding for noncompliance relating to the emergency transfer plan. For MORs conducted after December 14th, 2017, a finding should be issued for noncompliance related to the emergency transfer plan. Reviewers should use discretion in issuing corrective actions regarding compliance of the contents of the emergency transfer plan. The reviewer may also use discretion in issuing corrective actions regarding the applicability of the owner agent's adopted emergency transfer plan and consider issuing a finding regarding application of the wait list of how they adopted their preference and priorities if it's not in line with their written policy.
And we have a few more questions here. The
Okay.
first one is, I am an account executive. How involved am I expected to be in helping coordinate emergency transfers?
Yep, good question. And I think this question can also be taken from the PBCA perspective. So if a PBCA gets the same call.
Yes.
So as a HUD staff for PBCA, owners may contact you for information on your assisted projects in your area. And providing information, knowledge whenever possible with what vacancies are in your portfolio would be helpful. You may also refer them to the management agent in that area to see what they may have available, or you can certainly develop a greater support system for your owner's agents. There's a great Chicago model in place right now for folks in that region to where they have a listserv. Owners have notified HUD staff of any VAWA preference that they have, and there's a listserv going out. So if there is outreach to the HUD field office in Chicago, at least they email blast to all the owners who have this VAWA preference, asking them, do you have vacancies, and are you able to take somebody immediately for the move-in?
Yes, very good.
So I think eventually, big picture, we'd love for other field offices to adopt that as well.
Yes, I agree. Okay, we have another question. Okay. HUD's current model emergency transfer plan does not contain all the required elements of the VAWA final rule. Should a finding be issued during an MOR if a property used the HUD's plan without adding all the missing elements? And I believe you touched on this a little bit during your presentation.
Yeah. And so we have gotten this question a couple of times, both from owners and our PBCAs. And the model form contains the general provisions of the emergency transfer plan that applies to HUD programs. And as an owner agent, you must consult with applicable regulations and program-specific HUD guidance when developing your own emergency transfer plan, and to ensure that the plan, includes all the required elements. So you as a reviewer, if you find that the property adopted a plan that does not contain all the required elements, this should be cited as an infraction or finding in the MOR. And the reviewer should use discretion in issuing the finding versus observation or recommendation. And in this, we did give some wiggle room for owner agents to craft this emergency transfer plan. So if the MOR was conducted December 14th or later, that's when we want to start seeing the findings in the reports. If it was prior to, then HUD or PBCA doing an MOR can do an observation.
Yes. Another question. We received a complaint from a tenant that requested an emergency transfer. The property informed the tenant that the owner will not assist with moving costs. In cases of emergency transfers due to VAWA crime, is the owner required to pay the tenant's moving costs?
Yeah, that's a great question.
And I've actually seen, I've gotten this question a couple times.
Oh,
Yeah.
great. Would you like to answer? No.
I'll let you have it.
So that is a very popular question. So the VAWA final rule does not require that the owner agents pay the moving costs for households. So if their move out is to a non-HUD assisted property, there may be application fees. This could include a deposit or any physical expenses for the physical move of belongings. However, for HUD programs that have existing guidance related to paying cost or unit transfers, then owner agents should follow that existing guidance. But big picture is owner agents are not responsible for these costs to move the families.
Yes, thank you. Okay.
All right, so we will go ahead and continue with a few more slides in the presentation. So next I'm going to touch on topics before we wrap things up, and let's talk about confidentiality and record keeping. So given possible significant safety issues faced with victims of a VAWA crime, it is critical that owner agents establish or update existing policies to maintain the confidentiality and privacy of victims who seek protections under the VAWA Final Rule. The VAWA Final Rule clarified that any information submitted to owner agent under or including the fact that the applicant or tenant is or has been a victim of a VAWA crime must be maintained in confidence by the owner agent. VAWA information should not be provided to employees or contractors unless required by law. It should not be entered into a database or provided to others without consent from the victim or unless required for an eviction action or by law. Owners and agents should secure all correspondence with personal interaction with the victim and make sure that that information is kept confidential. Now, when an individual requests VAWA protections, the owner or agent should document victim's preferred mode of communication. The victim may designate an attorney, an advocate, or other secure contact for communications. All VAWA communication must be maintained separate from the tenant file. Section 11 of the housing notice lists some best practices to collect information and avoid unintentional disclosure of confidential information. If you are to conduct the intake session in a private room where the individual and staff can talk without the risk of other staff or clients overhearing, communicate to the individual with property management staff person who is responsible for handling questions or complaints about the confidentiality, and ensure relevant staff understand the confidentiality policies and procedures through regular staff training. You can also post notices about the importance of maintaining these private records throughout the office, and clarify information sharing policies with referral agencies and other service providers and business partners. So some things to look for when you're doing your management occupancy review for confidentiality of VAWA correspondence is confirm who has access to documentation of VAWA claims, how or where VAWA correspondence is maintained, and documentation of victims' preferred mode of communication. All right, so next let's discuss record keeping and reporting. Now, the VAWA Final Rule requires owners to keep confidential records of all emergency transfers requested under its emergency transfer plan and the outcome of such request, and to retain these records for a period of 3 years or for a period as specified in program regulations. The VAWA Final Rule further requires that these requests and outcome of such requests be reported to HUD annually. HUD plans to add these data elements to a future release of tracks, or also working with our systems to see if there's a better alternative for that. So some things to look for when you're doing your looking at record keeping and reporting is ask about the number of VAWA claims and transfer requests for the past year, and confirm the time period of records for VAWA claims that aren't being maintained. So during an MOR, the reviewers should use discretion when issuing corrective action regarding breaches of confidentiality as well as record keeping and reporting. The reviewer may need to consider the severity of the infraction, if the infraction is systemic, and if the property is new to VAWA requirements. And I think that last bullet about being new to VAWA requirements is really just breaking up your Section 8 owners and your 202 pracs.
Yes.
Okay, so during an MOR, we have broken out the 9834, so just heads up that right now the current 9834 that is out does not include the updates to the VAWA Final Rule. And on this slide we have broken up some suggested corrective actions or comment placements that you can identify your findings or recommendations for enforcement. So take a look at these questions. I don't have to read them out. We will share the presentation with you. But take a look at these questions and kind of see in the 9834 where's the best placement for you to identify that finding. At the end of the day, this is a housing notice that's public, so the owners do need to adhere to VAWA requirements and be creative in using your flexibility where to put in that finding in the existing 9834. And I think is this the last slide? We're about to wrap it up. Okay. So we have, so Chris has joined us.
Hi.
So she is sitting next to us, and she fielded the questions that we're going to announce next. So if we can get the next slide to display the questions for us, we can read them. All right, so the rule talks about bifurcating the lease in the event of an emergency transfer. What guidance is there about the security deposit from the owed unit? Would part of it be refunded to the person living in the unit? It's a great question. We've talked a lot about this.
We have.
So I can take a stab at this one. This one's very tricky. So I would suggest also coordinating with HUD office or your PBCA with the enforcement part. So at the end of the day, if you have a bifurcated lease, there is a security deposit tied to that unit. My initial response would be that the security deposit would remain with that unit. So the remaining family members would not need to pay a new security deposit. And but I would definitely suggest seeking with your counsel. This could be a court issue also, so you'd want to seek guidance from your counsel as well.
Yes, exactly. Next
You want to read the
question.
next one?
Yes. Is the owner required to create their own written emergency transfer plan, or can they use the model plan and just fill in the blanks? Carissa, you want to take that one?
Sure. Yeah, and I think you addressed this, Danielle, a few slides back. But so our form, the 5381, is a guide. However, it's not all encompassing, and it may not require all the requirements that are, or may not include all the requirements that are listed both in our notice and in the final rule. So it's important that owners and agents, when writing their emergency transfer plan, they can use the form as a guide, but they do need to make sure that they read carefully our notice and the parts of the regulation that are relevant to make sure that they've included all of the necessary components.
Great. Yeah.
And this is one thing just to add in that, because I don't want to create confusion with the 4 forms that were updated in the Federal Register today. So there are some tweaks in the existing forms. So you have the 4 forms in HUD clips. Those are the ones that you are OMB approved and you're supposed to be using. We have a few tweaks made to those 4 forms that are in the Federal Register today. Those cannot be used right now. So if you look at the emergency transfer plan, there may be a few tips and guidance of the required content. But just craft it on your own, use the final rule and the housing notice as your resource. So next question, do owners provide the 5380, so that's the notice of occupancy rights, and 5382, that's the certification form, to a household or all adult household members? Great question.
Yeah, I'll take a stab at that. Now, owners are not required to distribute them to each individual household member, but if an individual household member requests it, then of course they would issue it to them. But they're not required to issue it to each individual household member.
Right. So the requirement is that the one set of notices be given to each household. Each household,
exactly.
right.
Yes.
And usually that would be given probably to the head of household if it's being done during their annual recertification.
Okay.
And Let me mention one other thing related to that, related to the annual recertification, because we got a lot of questions and we weren't able to post all of them. But the annual recertification requirement, that's just for 2017. So after 2017, you no longer need to give the forms to the residents during their annual recertification. So we just want to make that clear.
Yeah, no, that's a great point, because
Yes.
in Section 8, there's a lot of forms that are given at the annual
Yes,
research.
right,
So
right.
great job clarifying that difference there. So it's just a one-time action for all current residents. In the presentation today, we suggested doing a recommendation rather than a finding. If you find out that those two notices, the Notice of Occupancy Rights Certification form, were not given to the household during the annual leading up to December 2017. So I think for any other instance, it would be a finding for your rejected applicant, somebody that's evicted. And usually there's attachments. So that can be your document of evidence saying that within the eviction letter, the attachment is Notice of Occupancy Rights, and we're also attached certification form. And if you want to include that copy in the tenant file, that's your call, but as long as a reviewer sees that the attachments were included, I think it'd be fair enough to ensure that y'all did do the job and provide appropriate notice.
Yes. Okay, the next question. In the circumstance that the owner has received conflicting information regarding a domestic violence declaration, is there a model letter the owner can use to request additional evidence from the victims?
Crystal, you want to take this one?
Sure. Unfortunately, we don't have a model letter. We will leave it up to the owners and agents to craft their correspondence appropriate to each situation. Should you need guidance, please do contact the field staff or your PBCA, and we can help you with that.
All right.
Okay, I'll read this one. What does it mean to use discretion when issuing a finding to an owner or an agent?
Yeah, and I think with this one, it's a great question. Just making sure that the owner is compliant with the final rule and the housing notice. So a lot of it is not as black and white as we'd like to see. The easier one, I would say, would be the emergency transfer plan. There's requirements that need to be in the plan, but then the owner agent may add other requirements. So just like anything else, when you're looking at house rules or tenant selection plans, seeing what's reasonable, what's not reasonable, and using discretion at that level.
Yes.
And what about, the difference between providing an observation or a finding on the MOR form?
Yeah.
We also, mentioned that the HUD and the PBCA staff should, in certain circumstances, they should use discretion in providing either an observation or a finding. I don't know if you can add any more to that.
Sure, no problem. So an observation is in the report. It's just as an acknowledgement that this is an area of noncompliance, and it does not require corrective action. Whereas a finding, the owner has to provide 30 days to correct that finding and some type of documentation or certification acknowledging that the finding is closed.
Yes.
But I'm getting the impression, though, that that each situation needs to be handled in and of itself. So whether you provide the observation or the finding, it will depend on the situation.
Exactly.
That's right. So we can't easily say, do this and this and that and that, because
Exactly.
it'll depend on each situation.
Exactly.
Okay.
Okay. Next question. Regarding the tenant selection plan, how much detail do we need to cover in the tenant selection plan? Do we need to just briefly mention a summary of VAWA, or do we need to mention details, summary and emergency summary and the emergency transfer plan as well?
I think that's a great question, so I could take this one. So if you think of tenant selection plan, who's your audience getting it? So it's any applicant applying for HUD-assisted housing. So as a reader, if I'm applying for HUD-assisted housing, I want to see how this is going to affect my placement on the wait list. So anything that's going to affect admission, placement of the wait list, preference, priority, or unit transfer policies, letting me know I have VAWA protections. All of that is important for that audience receiving the tenant selection plan. Now, what we've also seen is that some owners include this in their house rules, which is perfectly acceptable. The house rules is a part of the lease, so if you want a little more beef, a little more meat in your lease, you can include that in your house rules. And just letting tenants know what their requirements are, the VAWA protections are at the property.
Now, what about the emergency transfer plan, though? That seems to be causing some confusion. Should the emergency transfer plan be entirely separate from the tenant selection plan?
It is.
It is.
Yeah, it is.
Okay.
It's a separate written policy. Their final VAWA final rule has requirements, elements that you have to include in it. Now, this policy is more your internal policy. So you can post this in the public and have it in community rooms, make it available to residents. It's not required that you provide it to the residents, but if somebody asks for it, then definitely give it to them. But this is more an internal written policy of how you're going to treat the emergency transfers if an instance comes up.
Okay, so it sounds like the most relevant emergency transfer issue, shall we say, to put in the tenant selection plan would be whether there's going to be a preference for a victim.
Somewhat, yeah. I
and-
think the only thing I would add is also waitlist management.
Right,
Yeah.
right,
Yes.
right. But other things about, how somebody can make a request or how soon the owner will respond or, helping somebody with an external transfer. All those policies should be in the emergency transfer plan, which again would be separate from the tenant selection
Right.
plan, right?
Right.
Okay. And this question, Danielle, you touched on this question
Okay.
a little bit and said, are we required to change the locks of the unit after removal of the abuser?
Yeah, so it's obviously best practice, but the requirement of locks you would want to seek with your, check your state and local law. Big picture is if the perpetrator is a member of the lease, that's going to get a little sticky with changing locks because they are a member of the lease. But if the perpetrator is outside of the household, so a boyfriend or relative or something going on, some situation where they're not a member of the lease, that is a lot cleaner. I think that's more black and white answer. But best answer is, check with your local, your council at the property and see what the state and local law is for your jurisdiction.
Yeah, but this question, it did specifically say after the abuser has left
okay.
the unit. So, like you said, I think that would be best practice.
Right.
Yeah.
Yeah, and the owners have their own lock replacement policy
Yes,
and
exactly,
so on. Yeah.
Exactly. Okay. Next question. If this is a new lease, will the resident be required for the first full year of residency as applicable? Should the initial term be set to 30 days if the resident had already resided for a full year prior to bifurcation? And this sounds like it might be more specific to a 202 property because after the 202 pracs, I believe, they renew automatically in 30-day increments, in monthly increments. Yeah. So I think this one is specific to that. Chris, you want to take a stab at this one? You need me to read it again?
Okay, well, no. So I actually thought it was sort of a more general question, which I think we may have discussed that. So if a new lease is provided after lease bifurcation, the new lease is going to be for a 12-month period.
Okay.
So I think that's the main question.
Oh, okay.
Yes.
Got it.
Now, regardless of how long the remaining household member has lived there, when the lease is bifurcated again and there's a new lease, it's going to be for a 12-month term. I'm not sure, have we determined some of these policy issues we're still working on, and I don't know if you guys mentioned this, but we will be issuing some frequently asked questions on our website in the coming weeks. And we'll probably have a few series of those. So, check in, because some of these policies that we're still thinking about will be explained further in those questions and answers. But as far as a PRAC a section 202 or 811 PRAC goes, and the lease, have we determined whether the lease, I guess the lease is just supposed to be renewed on on a monthly basis. But if it's a new lease, if the lease is being bifurcated, then in the case of bifurcation, the new lease is going to be 12 months, regardless.
Okay.
Good
Right?
point. Yes, yes. And we mentioned that on the first webcast as well.
Yes.
And I think the issue that we're still determining is the time period that a remaining family member can stay to establish eligibility in a prac. And we're still trying to determine if that can be no more than 30 days, because the lease, after the first year, the lease the lease goes on a month-to-month basis. So if we haven't figured that out, again, that among other things will be in our forthcoming questions and answers.
Yes.
Okay.
Okay. Okay, next question. If an owner already met the Section 8 requirements to detailed VAWA policy prior to the VAWA change, will they be required to make any changes to those written policies? Or can they remain the same?
So I could answer that.
Okay.
Okay.
Okay, so yes, the key here is that the Violence Against Women Act was reauthorized in 2013. And it was reauthorized, there was a lot of additional provisions put into it. So again, the regulation that we've been talking about is HUD's implementation of the reauthorized Violence Against Women Act. So that's a long way to say that the reason we're doing this is because there's new provisions for everybody. So therefore, if in the past, because in the past, Section 8 projects had to comply with various VAWA requirements, there are new provisions this time that are in addition to what you've done before. So the best thing to do is, again, read our notice, make sure that you are complying with all the requirements on our notice, and no, you can't rest on your laurels if you've done it before. There's still additional things that you need to do this time.
Okay. We have about 10 minutes left, so I think we could take a few more questions here.
Yes, okay. Okay, next question. At what point in the eviction process should the VAWA notice be given with issuing the 10-day notice? And I
Yeah.
guess they're talking about the notice of occupancy right and the certification form.
Okay. So, yeah, great question. We've gotten this one a lot. There's a lot
Yes.
of confusion. If you have to give those two forms, the 5380 and 5382, right?
Yes, yes.
Multiple times for each action. So basically, if you are moving forward with an eviction, that initial notice where you say you will be evicted for XYZ, material non-compliance, or whatever the case is, that action is when you want to give the two forms. If you are sending other notices for that same action, you don't have to send those two forms for subsequent notice for the same action. Do you want to clarify? Is that clear?
Yeah.
You're
that's-
good? Okay.
That's clear, that's clear. Okay, next question. Would the move in be to a sister property or assistance? Let's see. Would the move in be to a sister property or assistance with the move in to another different property? And I guess they're kind of referencing if they move, would it be an internal or external?
Sounds like it's an external transfer
Yeah, it sounds like,
question.
and a sister property could be, if you're a management agent with multiple properties in that portfolio. But for your external transfers, I think the big messaging to get out is that the VAWA preference is not a mandated preference, so you as an owner get to decide if you're going to have that preference on site. And as an owner, you have to do your due diligence to help provide as much material to that family to help facilitate to some extent that transfer. So checking out what properties, building a partnership with your community or with other owners. It would be ideal if you're a management agent to check out other available properties in that portfolio, and if they have a VAWA preference implemented, I think that would help a lot. But it's really just communication, getting with service providers, talking with other owners, maybe the public housing authority in that area, seeing what they have available for that relocation.
Yeah, and also just keep in mind that If the owner does not have those adopted preferences, the applicant will have to go to the bottom of the wait list.
Right.
Yeah. Next question. Can you tell us again where on the management occupancy review, the Form 9834, should we include the VAWA observation and findings?
Sure. So we will.
You did mention this.
Right.
Just towards the end.
Yeah,
so.
it was. Oh, I see. So this question came in.
Yeah.
So yeah,
Okay.
we'll send you guys the PowerPoint presentation, and in there we outlined a few questions in the 9834 that you can lump it in or add in until that 9834 gets updated. So we're working to update the form to include the VAWA final rule.
Yeah, because I think currently now the 9834 only has one question specific to the
Tenant file security.
Yes,
Yeah.
exactly. Next question. When doing the MOR, can HUD or PBCA staff have access to the project's VAWA files?
Yeah, absolutely. Yeah,
Yeah.
I think that's the best way for you to acknowledge the enforcement and that they are implementing the VAWA final rule in accordance with regulations. So just have that conversation with them. How many emergency transfers have they gotten that last year? Look at their emergency transfer plan. Look at the documentation that's in the VAWA file for how that transfer request was handled.
I think even though it wasn't stated specifically that the concern is about confidentiality. And since the VAWA, any information related to a resident status or their request or whatever has to be kept as confidential as possible, are HUD and PBCA staff considered parties to whom that information is available based on our confidentiality requirements?
We are.
Yes.
Yes.
Yes. Okay, so the answer is yes.
Yes.
Good to know. Okay. Very
So
good.
do we have time for one more question?
Yeah, we have 4 more minutes
Okay.
left.
I
so
think
this-
we have. Go ahead.
Okay. The final question. If a resident is a victim and calls us with questions about VAWA, what are our confidentiality requirements?
Is that similar to what?
Yeah, so
Yeah.
similar to last
Well,
year.
no, but I think the question is, in terms of, if we want to contact the management company on their behalf, if HUD or the BBC wants to contact the management company on their behalf, or provide them with additional documentation, additional contact information for housing or service providers in the area. Again, to what extent do we need to make sure that we keep, that the HUD and the PBCA staff keep the information regarding that resident as confidential as possible? And one thing I'll say is definitely ask the resident what they feel comfortable with. But are there other guidelines people should follow?
Off the top of my head, there's, the Privacy Act, making sure you're following that. HUD staff and PBCAs, of course, want to keep the records confidential. So, as Krista mentioned, seeing what the resident's comfortable with and kind of going from there. But yeah, absolutely, the record, this is a very sensitive subject, sensitive information, and we do want the records to be confidential.
Yes.
So this wraps up our second webinar, and we really appreciate you sticking with us and joining us for this webinar. Us three are, so to speak, the VAWA team here at headquarters. So if you have questions, Carissa is doing an excellent job getting responses to you. So continue sending her questions and anything else we're fielding as a team if it's something that needs to get added to a FAQ. So with that said, thank you for joining us and have a lovely afternoon. Thank you.
Thanks.
Thank you.